The 4 essential estate planning documents that everybody should have. This is Michael Pevney, and I am an estate planning lawyer in Southern California. And in this video, we're going to talk about the 4 estate planning documents that everybody should have, no matter your age, no matter your level of wealth. The first is a will. And this can be a very simple will that just basically decides and describes where you want your property to go. And in places like California, if you have a small estate, meaning your probatable estate is less than about $185,000, the probate process can be sped up and you wouldn't have to go through a full probate. It doesn't really cost anything. And typically for people that are not homeowners but might have some financial assets and some small things that they want to give to certain people, we always want to have a very simple will. And in many states, there is a statutory will. You can go to your state's Department of State website or some government website, and there is oftentimes a simple will that you can fill out yourself and then either have notarized or witnessed by a couple of people, and you just basically fill out that document and you decide what happens to your stuff. The second essential estate planning document would be, in California, some healthcare documents. And in California, we have what's called an Advance Healthcare Directive, and that really encompasses 2 different things. First, what some people call a living will, or sometimes a DNR, and also a healthcare power of attorney. So the first part of that Advance Healthcare Directive, you decide what your end-of-life decisions are. Basically, do you want the plug pulled? Do you want advanced measures taken if your heart stops or if there's no brain activity? Or do you want sort of the right to pass on without any extreme measures being taken? You know, do you want that breathing tube or feeding tube removed, that sort of thing? And then the second part that an Advanced Healthcare Directive does is you can appoint a healthcare power of attorney. You appoint the person that makes decisions for you, as well as an alternate or even a couple of alternates. So that's the second document. Healthcare documents like an Advanced Healthcare Directive that we have in California. Again, this can be found. There's a statutory document that you can find, and you have it either witnessed or notarized, and it is in effect. The third essential estate planning document is a power of attorney. This is a financial power of attorney, sometimes called a durable power of attorney. In this document, you choose somebody or more than one person to take over your finances, either if you can't or if you don't want to. So a durable power of attorney takes effect or remains in effect after you are medically incapacitated. And in this document, you can name more than one person, and they can take this document to the bank. There's all sorts of different types of financial acts that they can do. Sometimes that even includes taking care of some estate planning, taking over any business interests that you have, writing checks for the bills, that sort of thing. So if we're medically incapacitated, we almost always want to choose one or maybe more than one person to take care of our finances until we can do it again. And sometimes if we're older or have a serious physical disability, we want that to take effect immediately, so somebody can go to the bank on our behalf even before we're medically incapacitated. That's really your own decision, or maybe a decision that you should make with a lawyer. And the fourth, and this really isn't a document, it's more of a way of handling your finances, we want to designate beneficiaries on all of our accounts. Almost every bank account, life insurance policy, retirement account, non-retirement investment account has some sort of beneficiary associated with it. Sometimes for bank accounts, it's called a TOD, transfer on death, or POD. POD is... I forget what that stands for. Anyway, a TOD beneficiary means it transfers automatically to the person named. And then we can always nominate beneficiaries on any investment account, whether that's whatever, Vanguard, Fidelity, Schwab, Robinhood, anything like that. And also, we always want to name a beneficiary on our retirement accounts. Oftentimes, that has to be a spouse. If you're married, sometimes you can name other people as well, depending on your state. and that sort of thing if your spouse signs off if you're married. So those are the essential estate planning documents or acts that we want to create to create an estate. We want a simple will. We want medical documents like an Advance Healthcare Directive. We want a financial power of attorney, and we want to designate beneficiaries. All of these things will often take our estate out of a full probate scenario, unless you own a home. And in California, if you own a home, for the most part, I recommend that people set up a trust, a revocable living trust, so we can avoid a full probate process. Because the full probate process, if the value of our probate assets, and that will usually include a home, is over about $185,000, we have to go through that process. It takes a long time. There's no privacy associated with it, and it costs a lot of money. Oftentimes, in the area where I live and practice, easily $50,000 or so. But everybody, as soon as you turn 18, we should have those basic documents in place: the will, the healthcare documents, the advance directive, and then name beneficiaries on any account. If you've got questions about this or anything else related to estate planning, you can set up a time to meet with me for free if you live in California by going to ocestateplanlawyer.com. There should be a link in the descriptions. Please feel free to ask a question in the comments section. I'm oftentimes able to respond directly. Thanks for your time. Thanks for your attention.